I've been asked today to share my knowledge and expertise with you, gained over a 26-year career as a practicing solicitor, leading a team of advisors working with elderly and vulnerable clients who often lack capacity to make some or all decisions for themselves. I'm also a daughter and a sister, daughter of a strong, independent woman whose journey with dementia began probably at least 5 years ago and was formally diagnosed with mixed dementia at the end of 2017. Sister of 2 siblings who are both doctors and, like me, are struggling to keep their mother safe and independent in her own home for as long as is reasonably possible. I talk to you today, therefore, not only as a fellow professional, but also as the family of a patient in your care. When I qualified as a solicitor in 1992, the legal landscape of capacity and making decisions for those who could not do so for themselves was very different. Both our professional worlds have come a long way since then, and our practices have had to continuously evolve to adapt to that changing landscape. The Enduring Powers of Attorney Act came into force on the 26th of June 1985, and for the first time allowed individuals to plan for circumstances in which they could appoint an attorney to act on their behalf and whose authority was not revoked by their subsequent incapacity. It became a key part of the planning process alongside making wills, for most clients consulting with a solicitor. But they were not foolproof, and as they only extended the attorney's authority to financial matters, they often caused more trouble than they were worth. I'm reminded of a case I was involved with in 2003, where the attorneys under an enduring power of attorney were a solicitor and a family friend. Mother, who was in her 90s, we shall call her Mary, had lost capacity, and her finances were managed exclusively by the attorneys. It's fair to say her daughters did not see eye to eye, and not appointing them to act as attorneys themselves was a sensible decision. Sadly, Mary's health deteriorated and she required carers 24/7. One daughter lived 5 minutes round the corner from her mother, and whilst was on hand to manage a package of care in the home, soon tired of the time in doing so, and when carers failed to appear on a regular basis, declared the situation as unsafe. She duly found a suitable nursing home for Mary and approached the attorneys to enter into a contract with the home and sign a standing order mandate for the agreed weekly fee. The other daughter, who was still working abroad for significant periods of time and unable to contribute in any way to her mother's care or managing the situation at home, was adamant that her mother should not go into a nursing home and threatened the attorneys with legal action. Her argument centred on the fact that the attorneys did not have authority to make decisions in relation to health and welfare, and by signing the contract with the nursing home, they were in effect endorsing Mary's move into care and acting outside of their remit. In this case, even the court did not know what the correct answer was, and whilst all involved were scratching their heads, the client was kidnapped by her daughter and pushed through the doors of the nursing home late one night. I'm pleased to say, of course, Mary settled well and spent her last few happy years there. Possession, as they say, is 9/10 of the law. Joking apart, it was becoming clear and clearer that provision needed to be made also for the attorneys to be appointed to make health and welfare decisions, and better guidelines put in place for attorneys and healthcare professionals being asked to make decisions for those who cannot do so themselves. The draft Mental Incapacity Bill was published on the 17th November 2003, but in February 2004 was renamed the Mental Capacity Bill. At the time, Hansard reported, the committee suggested that the bill, being about how to maximise mental capacity, should be renamed the Mental Capacity Bill, and we agree with this recommendation. The bill will reform the law in order to improve and clarify the decision-making process for those aged 16 and over who are unable to make decisions for themselves. It will also offer to people who have capacity the choice to decide how they are cared for in the future by introducing for the first time new ways to plan ahead for a time when they may lose capacity. The distinction the Joint Government Committee highlighted at that time was key. For the first time, the emphasis was very much on planning ahead to appoint attorneys to make all decisions, not just financial ones. The bill was also clear on decision-making by those judged not to have capacity and those that may have limited capacity to make some decisions for themselves and not others. The Mental Capacity Act 2005 in its final form received royal assent on the 7th of April 2005 and came into force on the 1st of October 2007. It is supported by a code of practice extending to 301 pages, providing extensive guidance on the principles laid down in the Act. Lord Faulkner, the Lord Chancellor at the time, commented in the introduction to the code. He said, "A number of people will be under a formal duty to have regard to this code, professionals and paid carers, for example, or people acting as attorneys or as deputies appointed by the Court of Protection. But for many people, the most important relationships will be with a wide range of less formal carers, the close family and friends who know that person best, some of whom will have been caring for them for many years." It is clear to me that in the case of Mary, the views of her two daughters were essential, but Mary herself should have been assessed and given the opportunity to be involved in decisions about where she lived, even if her understanding was limited. The parties involved were so busy arguing between themselves because Mary had been declared incapable of managing her own financial affairs, that she was not even asked a question about the most basic of her human rights. So what does the Mental Capacity Act now give us as professionals working with elderly and vulnerable people, and how is it an essential tool in safeguarding those members of society? For a start, it gives us a definition of a person who lacks capacity. I quote, "means a person who lacks capacity to make a particular decision or take a particular action for themselves at the time the decision or action needs to be taken." No longer can we simply declare a person lacks capacity as a blanket assessment of their ability. Helpfully, we are presented with 5 basic principles which I refer to almost daily in my work, and I would suggest you probably would and should too. They have become our mantra to stop and think before we give any advice to clients. The 5 principles are: number 1, a person must be assumed to have capacity unless it is established that they lack capacity. Number 2, a person is not to be treated as unable to make a decision unless all practical steps to help him to do so have been taken without success. Number 3, a person is not to be treated as unable to make a decision merely because he makes an unwise decision. Number 4, an act done or a decision made under this Act for or on behalf of a person who lacks capacity must be done or made in his or her best interests. And number 5, before that act is done or the decision is made, regard must be had to whether the purpose for which it is needed can be as effectively achieved in a way that is less, not more, restrictive of the person's rights and freedom of action. If we had known and applied these principles to the case of Mary, we may not have changed the outcome, but we would have certainly achieved it more quickly and without the need for expensive lawyers. So how as GPs do you need to have regard to these 5 principles? Patients will often present perhaps knowing that their memory is becoming a problem. Signposting to advice to make a will and put in place lasting powers of attorney before they are no longer able to do so is key advice, and will allow the so appointed attorneys to make decisions in accordance with the 5 key principles. Passing this advice on to worried family members is important too. Of course, they may ask you to be involved in the process as a certificate provider. This is a person who countersigns the document confirming that the person making the lasting power of attorney, that is the donor, understands its purpose and the scope of the authority it gives to the attorney. No fraud or undue pressure is being used to induce the person to make the power, and that there is nothing else that would prevent the lasting power of attorney from being created. The choice of certificate provider is an important and personal decision, and there are 2 types who can fulfill this role. First, a knowledge-based certificate provider, who is someone who has known the person making the power personally for the previous 2 years. A skill-based certificate provider who has relevant professional skills and expertise, for example, a GP or another form of healthcare provider. Interestingly, the British Medical Association does not provide guidance for GPs on whether they should act as certificate provider and what they need to consider if they do, and that may be why we are seeing increasing numbers of GPs refusing to undertake the role. My own view is this: if you are satisfied that the criteria are met as set out in the Code of Practice, and could imagine yourself happy to give a formal legal statement or even evidence under oath in a courtroom to that effect, then go ahead. You could be safeguarding your patient's future and acting in their best interests. Make a contemporaneous note of the discussion you have with your patient, and at the very least, if you are challenged, you will not be relying on your own memory. If you are unsure, then do not become involved, but assist the patient and their family in finding someone better qualified who can support them in making lasting powers of attorney. Sometimes, of course, you may be asked to actually act as a health and welfare attorney, and that is a subject on which the British Medical Association has published specific guidance for doctors. I quote, "In the BMA's view, there is nothing to prevent doctors accepting requests from patients to act as health and welfare attorneys. Any such request should nevertheless be considered carefully, as it may involve some risk of exposing health professionals to potential conflicts of interest. In particular, doctors should avoid acting as attorneys where there are actual or perceived financial conflicts of interest." In addition, in the BMA's view, doctors acting as health and welfare attorneys should never be involved in the preliminary assessment of the patient's capacity prior to the power of attorney being used. In short, proceed with care. But what happens if you are asked to adjudicate between warring family members, as in the case of Mary? Stop and think. Capacity to make a decision is time and decision specific. Could that patient be helped to make the decision for themselves? Could questions be asked of the patient in a different way? Could the patient be seen in their own home in a less threatening environment than your consulting rooms? We recently paid for my mother to be assessed by a private social worker, a lady with many years of experience of carrying out capacity and best interest assessments and acting as a court of protection visitor. I know that this is a luxury beyond the finances of many families, but as children we felt unable to have a discussion with our mother about her diagnosis and how that time may be approaching when she would need help either at home or full-time care in a residential setting. We're not unusual in that. I am familiar with such assessments as I use them when I am appointed as a deputy or attorney in a professional capacity. But my sister, who is a consultant anaesthetist, expressed her thanks and almost surprise to the assessor about the excellent way in which she settled my mother and used every technique to facilitate her making her own decisions, even though she ultimately felt my mother's illness had contributed to such a lack of insight. She did not have capacity to make decisions about her future care. Time and decision specific. Remember those words. So what next steps for us as a family in relation to my mother? She refuses to engage in any discussions about the future and is losing weight. She forgets to eat, of course, but is adamant when challenged that she does. She is only 50% compliant with her medication, even when it is delivered to her on a weekly basis. She can no longer make outgoing telephone calls, though will answer the phone if we call her. Her short-term memory is now so poor she will ask you 5 times in the space of a minute if you take milk in your tea. She has not had access to her finances for over 12 months now, but will tell you she goes to the bank every week. Her driving licence was revoked on diagnosis, but she continued to drive for 3 months as she hid the letter and we did not know. Even now, 15 months later, she tells people that I stole her car from her drive in the middle of the night and she's going to get it back this week. She recently started feeding her cat, who died 5 years ago, and walks often over a mile to our house saying she's on the way to visit her parents, who died 23 and 41 years ago. Physically, she is very fit and has no insight into her ever-declining cognitive function. She still goes to concerts and the WI with her neighbour and still remembers who her children are, if not always her grandchildren. It's clear to us her best interests are met by keeping her in her own home. Sadly, however, she will not accept a carer visiting or even a call button for emergencies. We have for now done everything we can to keep her safe. Her telephone only accepts calls from numbers it knows to prevent salesmen taking advantage. We have duplicate keys to all her doors and a video doorbell that watches her come and go and any calling visitors. We have made sure there are no gas appliances other than the central heating and have programmed and locked the thermostat so she cannot change the settings and get cold. Have we thought of everything? Probably not. And do I dread every day that there will be a crisis requiring a hospital admission and a subsequent discharge to a nursing home? Yes, I do. Despite the Mental Capacity Act and its monumental change in the way we deal with people like my mother, there are still plenty of cracks for patients to fall through. And currently, we do not have a clear way to continue to keep her safe. My mother is not a danger to herself. She lives in a fog of self-soothing memory loss. If she gets upset, it's soon forgotten. There would be no grounds to section her, and we cannot force her into a nursing home. We would have to trick her into entering and then lock the door, invoking a deprivation of liberty safeguard order. We are not an unfamiliar set of circumstances to you all, I'm sure. We are fortunate to be looked after by a wonderful GP who has spent time discussing with us the options we have for safeguarding our mother. A dole's order would be an obvious step, and the British Medical Association and the Law Society have together produced some useful guidance for GPs with patients like my mother. Again, I quote, "Where an individual is being provided with care and treatment in circumstances that amount to a deprivation of liberty, that deprivation has to be authorised. Factors that indicate that an individual may be deprived of liberty include that the person is confined to a restricted place for a non-negligible period of time, that the person does not have the capacity to consent to their care and treatment in those circumstances, and that the person is subject to continuous and complete supervision and control, and that the person is not free to leave." Sounds pretty scary, doesn't it? Even though my mother has been assessed at being medium to high risk of malnutrition, an emergency in the middle of the night she would not be able to deal with, and at risk of wandering, I'm still not sure that depriving her of her liberty is right now in her best interests. And would you either as GPs wish to make that call? Fortunately, there is help on its way in the form of the Mental Capacity Amendment Bill currently trundling its way through Parliament. It is proposed that amendments would see the cared-for person and any appropriate person or independent mental capacity advocate, otherwise known as an IMCA, who is supporting the person, given key information regarding the process and the person's rights as soon as practicable after an authorisation for a DOLS has been given. I suspect also we will see a lengthy code of practice and maybe some clarity for families stuck in the middle of a situation with no obvious way forward like us. Let's hope so. I hope this has been a helpful look at some practical issues you face in the course of your work. It's a lengthy subject. I haven't even touched upon the work of the Court of Protection, independent mental health advocates, deputyship orders, and what to do if you are asked to provide a formal assessment of testamentary capacity for one of your patients following the test set down in the case of Banks v. Goodfellow. It goes without saying, if it would be helpful, I can of course cover those subjects in future talks and would be more than happy to assist you if you wish to contact me. Sharing information and practical solutions for those working on the front line is a key driver